This program is a paid commercial announcement from Jacob Media Partners and does not reflect the views of WPHT or its management. Today's program is pre-recorded.
Jacob Media Partners presents The Adam Malamut Show. Real people, real perspectives, real opinion. Presented by the law offices of Adam Malamut and Associates. Powered by InjuredWorkers.com. And driven by Jaguar Land Rover Westchester. Now, live from the Malamut and Associate Law Studios, The Adam Malamut Show. Hosted by Adam Malamut.
And a good Saturday evening, everyone, and welcome to the Adam Malamut Show. Real people, real perspective, real opinion right here on Talk Radio 1210 WPHT, fresh off of back-to-back great radio programming, Adam. Tip of the Kango hat to you, sir. I thought the last 2 weeks, the programming content was spectacular. Really good information for the listening audience. Well done by you, and good Saturday to you, sir.
Thanks, Krause. Happy Saturday. You know, it's been a hot week. Temperatures are rising. We know that we're in the middle of summer, and with that, I hope everybody's staying safe, stay hydrated, and please continue to practice your social distancing. This pandemic is something that we should take seriously. Way too many people have been unnecessarily infected. We've lost a lot of people in our communities. Wear a mask. Make sure that you're safe. We are practicing social distancing in our studio, and I hope that you are wherever you are. Before we get started tonight, and Mark Natale, I'll be welcoming him in a moment. He's one of our attorneys here at Malamut Associates. He is a subject matter expert in employment law. I need to express condolences and talk about the tragic loss of the most iconic civil rights figure that we had up until this past week. I should say living up until this past week, and that is Representative John Lewis. People don't realize the impact that he has had on civil rights, which extend well beyond racial barriers. Civil rights benefit all of us. In 1965, Representative Lewis famously marched in Selma, Alabama, at which time he was brutally beaten by police. This added to his platform and, you know, to his credit, where most people would be treated disrespectfully, violently, and go away, he felt that it empowered him to carry his message and empowered him to continue his work for more than 55 additional years. He passed away after a 6-month battle with cancer at the age of 80, but his legacy is going to live on. And I'm hoping that our listeners, and I know that the population that listens to our radio station here is largely conservative. I find it hard to believe that all of our listeners would not be interested in making sure that people have better than just equal rights. It seems crazy to argue for just being equal. I think every person in America, no matter your race, your originality, you know, where you came from, your place of origin, your religion, your sexual preference, should have equal opportunity to be successful. I don't know how anybody with a straight face could argue otherwise. So when you have the passing of somebody like Representative Lewis, in my mind, the greatest way to memorialize that person is to continue their life work. I have coined the phrase, community cannot happen without unity. By the way, we're going to have some Malamut Law t-shirts with that on there. So if you join our mailing list, malamutlaw.com, you'll be able to jump on there and you'll see some opportunities to get some of those t-shirts that we have coming hot off the press. But continuing Representative Lewis's work is very important. This is the way that we're going to make sure that our country sees change. All of the marches, all of the peaceful protests, all they do is say, hey, here we are. They don't affect change. Change needs to happen by supporting our legislators, creating laws, enforcing the laws, and creating the opportunities. for people to get ahead where they've otherwise been prevented, blocked. It shouldn't matter what color you are. If you have the qualifications, you should have the right to the same opportunity as anybody else. I'm starting off with kind of a tone of remembrance, but I will carry throughout this show some of the examples that we're going to use as we talk about the changing landscape in employment law tonight. We're going to talk about John Lewis and his work and what it has meant, excuse me, for people's opportunities and in combating discriminatory practices. That being said, it's great to welcome back Mark Natale. Mark, welcome.
Great to be back, Adam.
And we've had a great time doing this show together in the past. And tonight's show, I think, is going to be more informative than any other show that we've done because we're going to speak directly to our audience. We're going to talk directly about issues that affect everybody, from CEOs to company managers to members of the building trades to truckers, workers' comp recipients, people who have been subject to retaliatory practices, retaliation, people who are disabled or perceived to be disabled and treated differently. That violates the law. Returning to work after the pandemic or during the pandemic, there's all kinds of legal changes there. Equal pay. So we talked about people having a right to be paid equally. Well, we're going to dive right in on the New Jersey Equal Pay Act and talk about similar state and federal laws in other jurisdictions. I always give my disclaimer that we are in New Jersey. We practice in New Jersey and Pennsylvania. So our discussion of the law here may be different in your jurisdiction. This is a discussion. It's not legal advice. We always welcome people to reach out to us if you have questions. If it's outside of our expertise or outside of a jurisdiction in which we practice, we will make a referral. We will help you find the right lawyer. We're easy to reach. I'll probably do this a few times throughout the show. But if you visit www.malamutlaw.com, you can chat with somebody 24/7. If you call us at 877-567-5293, we're always available to speak. That being said, Mark, let's dive right in. Let's talk about the changing landscape in employment law cases.
Absolutely. And, I do want to touch in before we go to the break that there is a direct link between, Adam, what you've mentioned about John Lewis and what we're talking about today. John Lewis is one of the big six civil rights activists. He was integral in passing the Title VII of the Civil Rights Act of 1964. He was involved in the organizing and the lobbying for that, and that serves as a bedrock for the employment law that we practice today, fighting against discrimination, fighting against harassment, and giving all people a fair shot at the workplace. So in a way, I like to think that this work and the cases that we take up help continue that movement as we help to fight for employees. And I look forward to getting into not only how's the law changed and evolved over time, but what the current issues are when we get back from break.
So before we go to break, I want to make sure that people realize it doesn't matter how big your company is. It doesn't matter how small your company is. These rights are rights that you have. Legislators have created the rights as a result of the great work by people like Representative Lewis and other pioneers that were willing to fight the fight that many others turn their backs on. So we're going to talk about those types of companies, the large companies, the small companies, and why your rights are equal when we come back. We'll be back in a minute.
We must use this moment to recommit ourselves to do all we can to finish the work. There's still work left to be done.
The Adam Malamut Show. Real people, real perspectives, real opinion.
And back here on the Adam Malamut Show as we come to you on Talk Radio 1210 WPHT. Great show lined up for the listening audience. Educating the listening audience, Adam, employment law. When I hear that term, there's so much under that heading of employment law, how does it apply to me or to the audience or to the building trades? That's what we're going to cover today.
That's right. And, the misnomer is people think of employment law, and a lot of people think that it has to do with unemployment. Well, that's one piece of it. A lot of people think that it has to do with, severe, obvious discrimination. That's another piece of it. But there's so many other components of employment law, and a lot of times you'll have things that happen in the workplace that are violative of not just one, but 2, 3, 4 different types of law or statutes that it's overwhelming. You need an expert to weed through this. So in New Jersey, in Pennsylvania, if you are an employee, you have certain rights. You have a right to not be treated differently based on your gender, based on your race, based on your place of origin, based on your sexual preference. You have a right to not be treated differently based on a disability or a perceived disability. If I'm working for you, Krause, and you say, that Adam, God, there's something wrong with him. He walks funny. I may have nothing wrong. I may just walk funny, and I've been told I walk funny anyway. But that is discriminatory based on a perceived disability. Discriminatory practices are really broad. There's a lot of different ways to view that. Mark's going to get into that in a minute. But before we go any further, I just want to talk to you real quickly as an audience about the different types of employers. If you work for a doctor's office where there may only be a few people working there, and you go out on workers' compensation, and while you're out on workers' compensation, you're retaliated against, or accommodations aren't made, or you get fired for filing a workers' compensation claim, you have rights. If you're a truck driver and you're driving down the road and you're keeping your logs and your employer tells you that you need to change because the delivery's got to get there, you need to change your log, you need to keep a different type of log and modify your entries, that's void against public policy. You then become a whistleblower. That falls into employment law. And you are protected. You cannot be fired if you speak up. Do it through an attorney, but you cannot be fired if you speak up. If you work at let's just hypothetically say, a big box retailer that might be publicly traded and maybe have the largest market cap on the stock exchange, and something happens there where, perhaps you get sick, and as a result of getting sick, they change your job responsibilities, or they lower your pay or lower your hours when you come back, or you get terminated. It doesn't matter the size of the company. You still have the rights, and you shouldn't be discouraged or intimidated based on the size of the company. So, Mark, let's dive right in. Let's talk about what you've seen recently in trends in employment law.
Absolutely. And, you bring up a great point, Adam, and it goes into what I think is one of the biggest trends that we see today in employment law. And that's not only does the size of the company not matter, not only should that not deter you from bringing a claim. In fact, the bigger the company you work for, a lot of times the more protections you have. Because the way that the employment laws are written in this state, they put a greater burden on the corporation depending on how big the corporation is. So if you're working for a large company and you think I can never take them on, I can never challenge what they're doing, in fact, you're going to have more tools at your arsenal in order to protect yourself. And that dives right into what I think is one of the biggest trends that we're seeing, not only in our cases, but around the legal landscape even before the COVID-19 crisis, although it's amplified by the COVID-19 crisis. And that are cases where employees are injured, they're sick, they're dealing with health problems, and then they get retaliated against at work. And that is, to me, some of the most unfortunate cases, because you have individuals who are simply trying to work and provide for their family, and because of a health condition, now suddenly they're not able to work, they're not able to make a salary, they're a lot of times kicked off their health care. Now that aggravates their health condition, and that is an opportunity for us to really help people that are just trying to provide for their family. To me, the most anger-inducing cases of these, where we really get worked up and we really want to fight back for our clients, is when the health condition starts when the person gets injured at the job. To me, some of the most rage that I feel for our clients is when they're doing the job, they're working hard, they get hurt at work, and then they get tossed aside by their employer. It's all too often, but it's something that people are starting to understand better their rights. And when they get hurt at work, it's not simply that they can go on workers' compensation. It's not simply, okay, if I qualify for FMLA, I can take a set amount of FMLA leave. No, you have assertive rights to get reasonable accommodations. So that means you need to stay out a little bit more longer than FMLA would allow, then you can do that. If that means that you need to change your work duties to a certain extent so you can still work, then you have the right to do that. That's becoming even increased during the COVID-19 crisis because you have individuals who are getting sick, who need to stay out of work, who are afraid of going back to work, or have health conditions that puts them at risk during the COVID crisis, and they need reasonable accommodations. And we are starting to see those cases come into our office. We're starting to file those actions on behalf of people because employers are not giving these people the accommodations that they have a right to.
Are people making that conscious decision just out of fear to let their employer know? Is that the reason?
I think that sometimes people are afraid to let their employer know what their health conditions are. People are afraid to tell their employer, I'm afraid to go back to work because I have a heart condition and we're in the middle of a global pandemic. And people think, like Adam mentioned, that they're going to be retaliated against. And here's the thing. I always tell clients all the time, we can't necessarily stop retaliation from happening. We can try to manage the situation so that way you get your rights and nothing bad happens to you. And in fact, those are some of the best conversations I have with clients where I'm able to give them advice and everything all works out and we don't end up bringing suit. But if you are retaliated against, you are protected. You are protected, and it's not just a matter of collecting workers' compensation benefits. You are protected in filing a wrongful termination claim against your employer. So really, that fear, you should feel more confident in being able to be open with your employer, explain your health situation, and get to an amicable resolution or to pursue your rights in court.
I have a friend that told me that there's 3 different types of bad employers: cheap employers, employers who are jerks, and employers who are cheap jerks. And what we've seen more during the pandemic is employers act with all 3 of them. We, as many in our listening audience may know, and for those of you that don't know, we filed what I believe is still the largest nationwide class and collective action dealing with employee rights. And it's amazing. It's against a company that is very large, and I can't speak about the specifics of this case right now, but you would think that larger companies are sophisticated enough to realize that they're doing something that cuts against public policy and employee rights, and that's just not the case. We're seeing more bad behavior at this time, whether it's reducing people's pay for the work that they've been doing and treating them poorly and trying to drive them out, or punishing people like Mark just talked about who have concerns. They have real health concerns about going back to work. These are conversations that if employers aren't having with their employees and they aren't trying to protect their employees, quite frankly, they're doing their employees a disservice. And for the fact that the employees feel the loyalty to their employer to not go talk to a lawyer, it's crazy. If you're not protecting your health, your job's not going to make a difference anyway. So you've got to protect your health. There's nothing more stressful than health and financial issues. And those two dovetail together with these employment cases. Between the stress, the mental and physical health, and the financial ramifications. So, folks, this is going to be an interesting show. We're going to talk about a lot. We're going to give you a lot of information. If you have questions, reach out to us. www.malamutlaw.com, MALAMUTLAW.com, or call us at 877-567-5293.
And you can connect with Adam Malamut on social media by hitting him up on Twitter at Adam S. Malamut, ESQ. Back in a moment.
From the Malamut and Associates Law Studios, this is the Adam Malamut Show.
This is the Adam Malamut Show. Thank you for tuning in. Happy Saturday night. We're in a lot of information out there. We're talking about the changing landscape in employment law. Mark Natale is our guest. And folks, I can't tell you firmly enough, this pandemic is serious. Let's continue to take care of ourselves. Let's get things back to normal as quickly as possible. But we need everybody to participate and be responsible. Wear your masks, use your hand sanitizer, keep your social distancing, and let's get back to where we need to be in terms of a healthier country. That being said, it's a great segue, Mark. We're going to talk about some COVID litigation. There's a lot of litigation now as a result of the pandemic, and the reason being employers have not behaved well. So for a very reasonable mindset, people are afraid to return to work. They don't know that their place of work is going to be safe. They don't know that the measures have been taken in order to get them to a place where they can go to work and know that they're not going to be bringing something home and transmitting it to their family and their loved ones. Mark, tell us about the COVID litigation that you're seeing now.
Absolutely. So COVID and the COVID pandemic really rocked the landscape of employment law because suddenly the workplace changed drastically. People needed new rights. People needed new benefits. Those were ushered through Congress and through Trenton and Harrisburg. And now, as we get prepared for the reopening / second wave, and we're starting to see an even more bigger shift than we had in the beginning because we're out of that phase where everyone kind of understood, okay, we need to close down, we need to hunker down. We have situations now where people are trying to open. Some of them are unsuccessful. Some of them are maybe too soon. But also companies and employers are starting to figure out, okay, what am I going to do now? I rode this out for a couple months. I need to get my people back to work. And you have employers that are doing it the right way and working with their employees and coming up with plans that work and keep everyone efficient and moving. And then you have employers who are motivated by, if not outright malice, are so motivated by the bottom line that they're able to sacrifice their employees along the way. So one of the big concerns that I have, that I'm hearing from clients, are people that feel unsafe going back to work because their employer is not taking it seriously, that there aren't adequate social distancing precautions going on at work, that they're having them violate sometimes city ordinances or the executive orders of governors when they get in the workplace. And those people are afraid, they don't know what to do. And those individuals should feel empowered to speak out because they are protected under both New Jersey law and a new ordinance that was just passed in Philadelphia that helps protect them. And this is the first of its kind ordinance passed in the country to address this specific issue of employees who are afraid to get back to work because they don't feel their workplace is taking this pandemic seriously or keeping it safe. I think that this situation fits under the laws of other jurisdictions. For example, I think New Jersey law and its whistleblower protections already has laws in the books to deal with this situation. But Philadelphia really stepped out into the forefront and said, we're going to pass a specific law to deal with this. And what it does is it protects an employee from an adverse action. Now, adverse employment actions could be termination, demotion, changing of your schedule in a negative way. It can be a wide variety of things. And it protects an employee from adverse action if that employee makes a good faith communication that discloses information that may evidence unsafe working conditions that violate Pennsylvania or Philadelphia's public health order that may significantly threaten the health or safety of employees or the public. And if that disclosure was made to try to remedy the situation. So you have now a variety of things that businesses have to do in order to try to keep safe. They need to try to social distance. They need to, for example, only allow a certain number of people in a store at a given time. Now, a retail establishment might look and say, well, no, I'm not going to follow that. If someone's here, they want to shop, they want to spend money, I'm letting them in. Suddenly, they're violating the order. They're letting too many people in. They're creating a situation where the virus can spread. Now, with this new ordinance, if an employee speaks up and says, hey, we're violating this order, this is putting us all at risk, we need to fix this, and the employer says, hey, either go along with it or you're fired, that employee is protected in a way that they previously were not under Philadelphia or Pennsylvania law.
Does the employer, Mark, have the right to outline the guidelines? Or is this law saying that the law is going to outline the guidelines?
So that's a good question. It's a great question. And the employer has the right to come up with their own policies that work within the guidelines. And this, you're bringing up, I think, an important issue that goes to the other side of the debate. People are arguing, well, we can't just handcuff our employers. We need to have our businesses up and running. And that's true. And what that debate misses is a lot of times there are, corporate interests that push that debate and say any laws like this hamstrung the employees. No, there is enough room in the law now for businesses to operate freely because, like you said, Krause, they can come up with the guidelines as long as those guidelines fit the thresholds that the government says they need to. And when an employee raises it, they are not automatically in a situation where they automatically have to do what the employee says if they believe that what they're doing is legal. So they can go back to the employee and say, no, actually, you're interpreting this order wrong. This is how we're doing it. It's safe. And the key thing is, all this law does is it doesn't force an employer to just listen to every single little thing an employee says. All it does is, if that employee speaks up and tries to blow the whistle on this, that you can't fire them. And the key part about this that you might have heard me say when I recited the law, it talks about good faith complaints. And this is a common theme that you see throughout employment law. And it's also a common reservation people have because people say, well, I don't know if I'm right. I can't find the right answer. I'm not a lawyer. I'm not a regulator. I don't want to say anything if I'm wrong. The law wants to encourage people to speak up. So they don't put these protections on them only if they're right. They put these protections on them as long as they speak up in good faith. And that is what they did with this law. So as long as you're saying in good faith, hey, I truly believe that what we're doing here is illegal and unsafe, you're protected. You might be proven wrong in the end by your employer, but then your employer can't say, oh, well, you were wrong, so now you're fired. You're still protected. And that's a common theme for people who want to speak out about wage and hour issues. I've represented people retaliated for wage and hour complaints where they thought they were entitled to overtime. Turns out they weren't, but they were clearly fired because they complained about it. They're still protected. I've represented whistleblowers in SEPA cases in New Jersey where they complain about different safety regulations where maybe they were right, maybe they were not, maybe it was a judgment call, but the fact is employers are motivated to just get rid of whistleblowers, and it doesn't matter if they were right and wrong. I've represented people who complained about what they thought was an inappropriate, improper, illegal relationship between a supervisor and a subordinate that they felt was sexual harassing and was quid pro quo sexual harassment. And it turns out they might not have been right on all the facts of that. But then when that supervisor turned around and fired them for making that complaint, they were protected as well. So people out there listening, if you believe that there is something wrong going on in your workplace, whether it's COVID related, whether it has to do with safety in the workplace, whether it has to do with wages, hours, discrimination, any illegality, and you're concerned, you should feel free to speak up because you're protected if you have a reasonable belief. And if you are still concerned and you want to know what your rights are, then you should visit us at malamutlaw.com. And a lot of what I do is consult with these potential clients about what their rights are and how they can assert those rights in the workplace.
Mark, you mentioned SEPA. SEPA is the Conscientious Employee Protection Act. And I think that is probably one of the strongest statutes in the country. If you live in New Jersey, that Conscientious Employee Protection Act gives you so many protections. If you are an employee and you make a complaint about something that you believe is against public policy and you are retaliated against, not only do you have the protection from that act to not lose your job, but you have the benefit of potentially getting paid treble damages, punitive damages for being retaliated against, including your attorney's fees, including the costs. This doesn't cost you anything. Pick up the phone and call a lawyer. Call us. We will give you free advice. We will tell you what to do. But if you believe that you have something that you are being treated differently for, by all means, act on it. This dovetails into the mission of Representative Lewis. Representative Lewis believed that people should stand up for themselves. And our running theme today is, with employment law, if you don't stand up for yourself, nobody else is going to stand up for you. You feed your family off of your job. You feed your family off of your labor. By all means, protect it. We're going to take a break. When we come back, we're going to talk about bad behavior, needing help, and how we're going to hopefully impact and change the way employers look at their employees. I can tell you that here we value them as family. Hopefully we'll get others to do the same. We'll be back in a minute.
This is the Adam Malamut Show. Real people, real perspectives, real opinion on Talk Radio 1210 WPHT.
Real people, real perspectives, real opinion. Now back to Adam Malamut.
Welcome back. This is the Adam Malamut Show. I'm joined tonight by Mark Natale. We've had a great discussion going, talking about the changing landscape and employment law. We've also tried to create and impress upon you the importance of not just memorializing Representative Lewis, but continuing his legacy by effecting change and making sure that civil rights are rights for all, not just for the few, not just for the privileged, not just for the people who are born in a certain neighborhood or to a certain person with a certain skin color. These rights are fundamental rights that if you have the skills, if you have the ability, you should be able to have the same opportunity. You should not be denied for anything based on your skin color, based on your place of origin, based on your sexual preference, based on your gender. Equal rights are equal rights. And such an easy concept, but it's something that our country has continued to miss the mark on. Talking about it only gets us so far. We need action. Right back with that, I want to talk about ways that you can create action for yourself in your employment concerns. And it doesn't have to be something that you stress more about. The idea of going to a lawyer to ask a question should be something that helps you get informed. Law is the one area where you can, in good law firms, get some free advice and decide whether you have options, decide whether you're aggrieved and there's some sort of action you can take without you having to have fear of having your livelihood stripped away from you. Mark, we talked over the break about people's misbelief and the misnomer that every time you see a lawyer it costs you money. That's not the case.
That's not the case, and that's not the case in this area of law for the most part, and that's certainly not the case with the culture of our firm, which is trying to help people and resolve these situations for them. A lot of people think when they're having trouble at work, they get terminated, they're not allowed back at work, they're trying to figure out how they can make ends meet, can they qualify for unemployment, what are we going to do about the next job, and the last thing that it comes to their mind is, how am I going to pay for an attorney? And there are some attorneys out there that will charge consultation fees, that will it'll cost money just to get them on the phone, but that's not the type of service that we provide to our clients. And I've made mention to this before. Sometimes the most rewarding phone calls that I have are phone calls where I can give advice, where I can tell you what steps to take, your situation gets resolved, you're back in a good spot, and we never get to file a lawsuit. That's fine. I'm happy to help people in that way. And that is something that has truly picked up during the pandemic because people are just unaware of their rights and they just need an explanation. And these people are in an unfair situation because they are sitting at home trying to figure out what they can do, how they can continue to provide for their family, and they're interacting with a large corporation or human resources department or a business owner who probably has their attorney on speed dial if their attorney isn't just sitting in the room with them, and they feel that they're outmatched and there's no way that they can create equality in the bargaining and in the situation. That's where people should feel they can call us. They can go on malamutlaw.com. Our professional intake team will hear their concerns. And then they won't just hear from a member of our staff or someone out of the office. They're going to hear from one of our attorneys. They're going to hear from me. I'm going to be able to understand what's going on from them and give you direction, let you know what your rights are. Because otherwise, if we don't have law firms and lawyers out here offering this sort of advice to help people navigate, people will never know what their rights are. They will never be able to stick up for themselves, and they'll never be able to eventually, if necessary, bring cases to court. Because unfortunately, a lot of people only learn employment laws from their employer, and you can imagine what kind of education that is when your employer doesn't want you to know what kind of rights you have. That's why our phones are always on, and we're always willing to help people out.
If you're on workers' compensation, you are entitled to be accommodated in many cases for your injuries. Accommodation goes beyond compensation. That is accommodation. That is, if you have an injury, you can't be put back to work to do something that aggravates the injury until the doctors clear you to return to work. There's light duty often available. There are different types of arrangements, whether you used to stand for your work, now they give you an opportunity to sit. Your hours are modified. The type of work you're doing is modified, but you have rights. If you are disabled or perceived to have a disability, that cannot prevent you from getting a job, nor can it prevent you from being fired from your, or nor could that enable you to be fired from your job. Age. It doesn't matter how old you are. If you can do the job, you can do the job. So as I sit here across from Krause, who is at least double my age. Sorry, Krause. You know that there was going to be one in there. But if
it's okay, I'm good with it.
As I sit across,
because I'm good with
Krause,
the follow-up to this too.
Oh, this is going to hurt. But no matter what your age is, if you can do the job, listen, you can't let somebody take your livelihood and just idly stand by. You have rights. And that's why, and Mark's mentioned our website, it's malamutlaw.com. MALAMUTLAW.com. We have a toll-free number, 877-567-5293. You've got to get educated on your rights. And again, we're happy to speak to people. We're happy to advise you. Not every case is a case. Sometimes it's just you need to reassure yourself that you're safe. There's nothing more daunting than not knowing where you stand in your career and you've got a family to feed. Bad behavior happens all the time. Bad behavior is retrainable. Oftentimes people develop relationships in the workplace with their friends. They become friends with their coworkers. You don't want your coworkers to be treated poorly. You don't want yourself to be treated poorly. Toxic cultures can change, but unfortunately, sometimes it needs somebody to come in and help show them the way. This has been an amazing show today, in my mind, in my humble opinion. I think that we've gotten a lot done. I do want to circle back to Representative Lewis, and I want to talk about things that he has done real quickly. You know, his one of the things he's said is to be hopeful, be optimistic, never lose that sense of hope. I think that that's a great message. I think that just as great of a message, and one of my favorite quotes of his is, sometimes you have to get in the way. You have to make some noise by speaking up and speaking out against injustice and inaction. I hope that you'll continue to help his legacy and his life work progress. I hope that you're going to help create action, and I hope you stay safe during these troubling times. Thank you for tuning in. Again, I'm Adam Malamut. On behalf of myself, Mark Natale, and the Adam Malamut Show, I want to thank you. Stay well, and we'll see you next week.
We come to Selma to be renewed. We come to be inspired. We come to be reminded that we must do the work that justice and equality calls us to do.
Thanks for listening to the Adam Malamut Show, a Jacob Media production. If you're interested in learning more about the power of the radio hour, contact Joe Kraus at 267-261-3428.
This program is a paid commercial announcement and does not reflect the views of WPHT or its management. Today's program has been pre-recorded.